Judge LaRose, Mr. Ackley needs to turn on his camera and mic.
Okay, and
That
there
does
he
make a
is.
difference.
Mr. Ackley, good morning.
Good morning, Your Honors.
Okay, do you want any rebuttal time, Mr. Ackley?
May it please the court, Your Honor, I would reserve 5 minutes for rebuttal.
Very well. We're ready to go when you are.
I am here today representing Marcos K. Da Silva and William Comtois, homeowners in Lee County, and we are appealing a lower court judgment in favor of Deutsche Bank National Trust Company as trustee in trust for the registered certificate holders of First Franklin Mortgage Loan Trust 2006 FF8, Asset-Backed Certificates Series 2006-FF8. The first issue I bring before the court is that on November 10th, 2009, Deutsche Bank MERS as nominee for First Franklin, a division of National City Bank of Indiana. The endorsee of the note in this case, assigned to Deutsche Bank National Trust Company as trustee for FFMLT Trust 2006-FF13, Mortgage Pass-Through Certificates Series 2006-FF13, the mortgage and the note that are at issue in this case. That was the first and only assignment of mortgage of this note and mortgage before the court, below and here. The evidence was entered into evidence as defendant's exhibit number 1 as a certified copy of assignment of mortgage. It's in the record at page 286 through 287. And I would ask the court to pay particular attention to the language of that assignment of mortgage. It includes the language unto the assignee, together with all monies now owing or that may hereafter become due and owing in respect thereof, and full benefit of all powers and all of the covenants and provisions therein contained, and said assignor hereby grants and conveys unto the said assignee the assignor's beneficial interest under the mortgage, to have and to hold the said mortgage and note, and also the said property unto the said assignee forever, subject to the terms contained in the said mortgage and note. That's at page 287 of the record, and it's dated November 10th. That assignment of mortgage was recorded on March 12th, 2010. And again, that assigned everything to the trust with the series numbers 2006-FF13.
Let me circle back, Mr. Ackley. And I think your position is you're taking the position that the trustee didn't have standing. But let me look, if you look at the record, Deutsche Bank is in fact the holder of the note. Would you agree to that, or you still dispute that?
I would dispute that to the extent that they are in possession of the note, purportedly. But that doesn't mean they're the holder. If you look at Florida statute, and that's if Florida statute 673 applies, or chapter 673 applies, we have to look at 673-3021 for the specific terms under which somebody becomes a holder in due course. In other words, entitled to enforce, equitably entitled to enforce the note. In that case, there has
and I understand that, Mr. Ackley, but here also we need to look at what's been presented below. Wasn't there also further evidence that at least Deutsche Bank did enter a Bailey letter at trial showing the original note that was sent to its counsel before filing suit?
And that reflects possession. Record. I'm sorry, Your Honor. That reflects possession. I agree. Yes, absolutely. Okay. There's a Bailey letter. We're not contesting that. We're not contesting that. And they proffered a copy of the original note, and eventually the original note was referenced and it was present in the lower court. However, again, it was Deutsche Bank FF for series 2006-FF08, not Deutsche Bank series 2006-FF13. So they have something that is self-serving, and it's not in any way reflective of any alteration or change to the assignment of mortgage that was issued in 2009. In fact, and I would cite to the seminal case that people refer to with this the mistaken paraphrase, the mortgage follows the note. Well, that's true to an extent, but not entirely. Even Ortiz and McLean versus JP Morgan Chase Bank, they require it to be the holder. And in the Ortiz case, as in McLean, it's filed absent evidence to the contrary. There's a presumption, but in this case, there is evidence to the contrary. We have the only assignment of mortgage before this court is an assignment of mortgage executed in 2009, recorded in 2010, which concretely shows a transfer of both the note and the mortgage to a different entity, not the entity that's before the court. And there's nothing before the court to challenge that. There is no evidence whatsoever to show that that wasn't a valid assignment.
But if I may, Mr. Asher, I guess it goes back, doesn't the fact that someone is a holder in the note, once you have a holder note, someone has standing then to foreclose. Would you agree with that proposition? If you
I wouldn't, and here's why. When one refers to Florida statute 673-3011, we find out that a person entitled to enforce the instrument, and the plaintiff has referred to this themselves, the appellee has referred to this themselves, that gives standing to enforce the note, not to foreclose. And there's a huge distinction here. And the distinction falls upon the language, a person may be a person entitled to enforce the instrument. And yes, we're not arguing with that, even though the person is not the owner of the instrument or is in wrongful possession of the instrument. And there's the distinction. There's the rub. The fact of the matter is, if they're in wrongful possession, or they're not the owner and they're in wrongful possession, that doesn't provide equitable title. There has to be an indication, an exchange of consideration. There has to be an exchange for value for an equitable transfer to take place. Absent that equitable title, absent that equitable transfer, the mortgage can't follow the note for purposes of foreclosure. The entitlement to enforce the note, that's a different matter. And there may in fact be entitlement to enforce the note, but that's not the cause of action that was brought before the court. They're trying to foreclose. They have no right to have the note. They're in wrongful possession, and they're trying to foreclose and take away a house using a mortgage that can't be enforced because they don't have equitable right to do so. That's the key distinction. And I would say that, and I would point out to McLean, ALS, HSBC Bank versus Doucette, all of those cases still rely on the fact that there has to have been a valid holder in due course, not an inequitable possessor, which is what they're effectively arguing. Because we possess the note, we can enforce it. Well, that's not true. And I mean, the common argument to that effect is the FedEx or the UPS person delivering the note certainly doesn't have right to enforce the note, even though they're possessing the note. But the people who have possession of the note are before the court arguing that they have the right to foreclose are doing so without showing the court any ownership, any transfer of value, any consideration. In other words, no right whatsoever to enforce this note to foreclose. They may have the right to enforce for entitlement to enforce for a debt, but they have no right to foreclose because they have not shown the court any equitable ownership or equitable rights whatsoever. That's the first argument. The second argument is entirely different. And in this argument, we would argue that Chapter 673 doesn't apply at all. We would argue that since this note has been transferred to a REMIC, a real estate mortgage investment conduit, the note was certificated. And this argument was made at length in the lower court. It was pointed out that this is a REMIC. The testimony was that it's a REMIC. As a REMIC, the note has been certificated. In other words, it's been cashed. It's like cashing a check on your phone.
Yeah, Mr. Ackley, I was fascinated when I read that in the brief, and I'm trying to find out what authoritative Florida law there is that recognizes that I've basically taken a note and I've turned it into a security, and sort of like the debt sort of disappears.
Well, the debt doesn't disappear. I understand your point, Your Honor. I would argue that Chapter 678 and 679 apply. 678, 1031, I believe, is the section of 678. It even specifies that once the note is secured, 673 does not apply. The terms of 678 apply and 679 apply. because once it's certificated, what effectively happens is the trust is committing the cash flow from the notes that are put into the trust to certificates, their investments.
Isn't that, but that's a relationship between the trust and the beneficiaries. I don't know how that impacts the obligation of the mortgagor.
Because the certificate holders have already paid for the note. They've paid the trust for the note. It's just like cashing the check. Nothing changes physically on the check, but the check has been cashed. The monies have been transferred from one bank to my bank, and that note or that check can't be cashed again. The note can't be cashed again. It's already been cashed. So has
it been cashed, or of the beneficiaries of this trust, they're basically buying into a cash flow of a packet of notes that have been taken on by the trustee.
Yes, that's exactly right. But those cash flows aren't from one note directly to one certificate holder. The cash flow is put into a pool and broken up into the different derivatives, and the certificates are invested in those different derivatives. So in other words,
but all those mortgagors remain liable, because if you just put them out of the picture, the cash flow stops.
But the mortgage isn't in the trust.
Is going to be very upset.
No, the mortgage isn't in the trust. The debt is. Now, the originator can still enforce the debt. It's just that you don't have a mortgage certifying. It can't secure the notes anymore, because they've been added to the trust. They've been pooled, and once they're pooled, they're not fungible anymore. They're not individual.
Mr. Ackley, if I may, because like Judge Lewis, I'm intrigued. Do you have any cases that support your position?
I have these
any cases at all, because that's, quite frankly, I think it's a novel argument. It's an interesting argument. That is there any legal authority that you could point us to that we could review?
We've been trying to get Florida courts to understand the UCC function and how UCC's Chapter 8 and 9 changed the nature of the note for a while. I don't have the case law in Florida at this point. I do have bankruptcy law that I can provide the court later, supplemental law, where the bankruptcy courts have clearly held that this certificate nature of the notes has altered the nature of the notes. But I don't have Florida court law. It would be a novel issue for this court.
All right.
The next issue that I really do want to bring before the court, however, is the limited power of attorney relied upon by SPS to bring this lawsuit on behalf of Deutsche Bank National Trust. And that can be found at page 224 of the record. That limited power of attorney, Your Honor, let me just pull it up. There are four distinct issues that create problems for the plaintiff and should have precluded judgment for the plaintiff in the court below. The first is that the limited power of attorney is incomplete. The limited power of attorney is dependent on language and terms that are articulated within the service agreement, the pooling and service agreement. Specifically, on page 228, there is reference under Exhibit A. There's reference to a pooling and servicing agreement for the asset-backed certificate series 2006-FF8. The so-called plaintiff in this case, or the party that it purports to be the plaintiff. The problem is that those agreements, service agreements, are incorporated. The language and the requirements, the duties and obligations are incorporated as part of the limited power of attorney. In fact, the language on page 224 reads, "Know all men by these presents at Deutsche Bank, etc. Pursuant to agreements listed on Exhibit A, the one I've just referenced to, attached here too, hereby constitutes and appoints the Select Portfolio Servicing Inc. By and through, et cetera, in connection with all mortgage loans serviced by the service pursuant to the agreements." Without the terms of those pooling and service, the pooling and servicing agreement, we don't know what the rights and obligations are to the extent of the agreement that's articulated in this power of attorney.
Well, let's see if I could talk a little bit about that, Mr. Ackley. As I'm looking at it here, okay, the actual authority itself, doesn't the power of attorney expressly authorize SPS to perform acts and execute documents in the name of the trustee for purposes including foreclosures? Would you agree with that?
I wouldn't. And here's why. When you go to paragraph 8 on page 225, the language of paragraph 8 is pretty specific. With respect to a mortgage or deed of trust, the foreclosure, the taking of a deed in lieu of foreclosure, or the completion of a judicial or non-judicial foreclosure, or termination, cancellation, or rescission of any foreclosure, including without limitation any and all of the following acts. And then it articulates 6 specific acts that the power of attorney conveys duties on the servicer to carry out, none of which is the foreclosure itself. And that's a key issue. They're not authorized to bring the foreclosure. They're authorized to—
Mr. Ackley, may I interrupt you for a moment? You are into your rebuttal time, but use your time as you wish.
Thank you, Judge. So those, I would argue those 6 arguments, those 6 elements do not convey foreclosure as an act that the plaintiff is entitled to do. The last issue I really do want to highlight is that SPS has brought this, has verified the complaint, and brought this in the name of Deutsche Bank Series FF 2006-FF08. However, on page 226 of the power of attorney, there is this specific language: nothing contained herein shall limit in any manner any indemnification provided by the servicer to the trustee under the agreement, or be construed to grant the servicer the power to initiate or defend any suit, litigation, or proceeding in the name of Deutsche Bank National Trust Company, except as specifically provided for herein. And there's nothing specifically provided for in this power of attorney that allows them to bring this lawsuit. They've argued that they're doing so as an agent and they're authorized to do so, but that flies in the face of common sense. If the language of their power of attorney specifically states they cannot bring this lawsuit in the name of Deutsche Bank National Trust Company, which is exactly what they've done, they're precluded from doing so. And with that being said, Your Honor, I would respectfully request the court to reverse the lower court's judgment in favor of the appellee. Thank you.
Thank you, Mr. Ackley. You'll have about 3.5 minutes for rebuttal.
Thank you.
Ms. Morat?
Yes. Good morning, Your Honors. Allison Morat for the appellee. Like many foreclosure appeals, the main issue here is standing. The appellants have failed to meet their burden on appeal to demonstrate error. There is enough evidence in the record to uphold the judgment. The note is endorsement blank. It was attached to the complaint. It was filed with the court, and plaintiff produced a Bailey letter at trial. This is enough under this court's decision in Mink and Engel. But the more interesting issue is that the note is a negotiable instrument. It meets the definition of a negotiable instrument under 673-1041. The appellants have not cited any authority to show that the negotiability of the note was destroyed. Rather, there is one case in Florida that's directly on point, and that's the Bousset opinion out of the 3rd District, and it deals with this very argument. And the 3rd District said that promissory notes, such as the one at issue in this case, are negotiable instruments. Plaintiff is the holder of the note. It had possession of the note, and that is enough to enforce the note and foreclose. And that's under 670.
But Mr. Ackley's argument, as I understand it, is that the assignment was to Series 8, and the party bringing the suit is the trustee of Series 13. So is that a gap that needs to be bridged to establish standing?
No, Your Honor. The plaintiff that filed suit is Deutsche Bank as trustee, trustee for the FF8 trust. There is an assignment that is to Deutsche Bank as trustee for FF13 trust. That doesn't matter. The assignment is superfluous. It's irrelevant to plaintiff's status as the holder of the note. There are a number of cases in Florida that speak to that issue as well. The assignment doesn't convey possession of the note to be the holder. Logically, when you look at the assignment, it's logically a Scrivener's error, the digit FF13 trust. There was a loan modification executed prior to the assignment that is conveyed in favor of Deutsche Bank as trustee for FF8 trust, which is the plaintiff in this case. The assignment comes after that. Given the volume of these foreclosures, there was probably a Scrivener's error, but the assignment does not matter.
Was that explained to the trial court, or the possibility or the actuality of Scrivener's error?
I don't think that there was testimony that there was a Scrivener's error, but I don't think that that matters either, because the case law says even if there's a conflicting or a confusing assignment of mortgage, even without explanation, it does not destroy the plaintiff's status as the holder of the note. The cases on that are ALS v. Garvin from the 4th DCA. We've cited that in our answer brief. Also, there's cases that say that plaintiff does not have to prove the identity of the trust. The trustee doesn't have to prove on whose behalf it acts. And that's the Ginsburg opinion from the 4th DCA, as well as the Harris opinion. So the plaintiff is Deutsche Bank as trustee. The identity of the trust, whoever's receiving the cash flow from this, does not matter for the purposes of standing and to be the holder of the promissory note.
So my comment to Mr. Ackley, you'd agree that because Deutsche Bank is in fact the holder of the note, it has standing to foreclose, particularly also, like you said before, it entered a Bailey letter at trial showing the original note was sent to counsel prior to trial. So our analysis focuses on that whoever is the holder of the note does have the authority or the standing to foreclose.
Yes, Your Honor. That's what our argument is the focus is on who has possession of this blank endorsed note, not whether or not there's an assignment out there that has a wrong trust series in it. How many foreclosure appeals do you see where there's an issue with an assignment of mortgage? There are numerous. And the case law fortunately says that these assignments are irrelevant to the plaintiff's status as holder. I also want to point out that the appellants did not cite to any specific provision of the UCC or Chapter 678 or 679 in their briefs. Mr. Ackley mentioned 673-1031, but that specific statute is not cited in the brief. It's not explained in the brief why that statute destroys negotiability of the note. So the argument's not materialized. There's nothing here for the court to accept this novel argument that's being presented. But if you really want to go and look at that statute and drill down into it, I think that you would see that a negotiable instrument is still a negotiable instrument under 673 if it's held in a securities account. So even these statutes that are vaguely referenced in the brief do not take this note outside of Article 3. It's still a negotiable instrument. The note and the mortgage don't disappear with the securitization process. And practically speaking, if that type of holding would halt the transfer of commerce in these notes and mortgages across the industry. So it would be a catastrophic result. Are there any other questions on the assignment of mortgage or negotiability? The last issue addressed by Mr. Ackley is the power of attorney that was produced as evidence in this case. And the power of attorney is a complete document. If you look at it, it references the servicing agreements, but it doesn't purport to attach those agreements as exhibits. So the power of attorney is a complete document. Second, the appellants don't have any standing to challenge plaintiff's compliance with the servicing agreement or the servicer's compliance with the servicing agreement. They're irrelevant to the true issues in this foreclosure case. Third thing is the power of attorney specifically allows the loan servicer, SPS, to do things in Deutsche's name, including foreclosure. Mr. Ackley referenced paragraph 8, and that references foreclosure. It also includes language, including without limitation, the following acts. And the use of the words, including without limitation, those aren't words of restriction. Those are words of enlargement. And if you look at the Black's Law Dictionary, it says that including without limitation denotes a partial list. It doesn't mean that SPS can only do the following things. So that argument is really a non-starter. And finally, The power of attorney is valid. The valid power of attorney is complete. It was properly put in evidence. But here, we produced a witness at trial with knowledge of the servicing relationship. She said, I'm an employee of the servicer. The SPS is the servicer for plaintiff. She had personal knowledge of this. We didn't even need the power of attorney to prove that relationship. It wasn't a necessary component. It doesn't destroy, even if you say the power of attorney is defective, it doesn't destroy this case. The court should still affirm. I think that I've addressed all the issues that were presented by Mr. Ackley. And if the court has any more questions, I'd be happy to answer them.
Thank you, Ms. Moran.
Thank you.
Mr. Ackley, 3.5 minutes.
Thank you, Your Honor. With regard to the requested sites with relating to the securitization of the notes, I would cite the court to Chadburn v. Park, 571 U.S. 377. It's a U.S. Supreme Court case that shows that there's no private right of action by the investors. And this speaks directly to the fact that the certificate holders are basically bondholders. They have no right to go after the debtors to the trust. It would be like somebody who bought a share of stock in Apple going after a company that's a debtor to Apple. And that's not how it works. They're not allowed to do that. With regard to the assignment of mortgage, I'd cite the court to the transcript, page 91, where the plaintiff's own witness has testified. The question to the witness by myself was, what trust does that indicate the loan was assigned to? It says Deutsche Bank National Trust Company as trustee for FFMLT Trust 2006-FF13, Mortgage Pass-Through Certificates Series 2006-FF13. An entirely different trust than the one you just a minute ago testified that this loan was in, correct? Correct. In fact, the assignment of mortgage actually retrodates the assignment, doesn't it, to a prior date. It says effective June 1, 2006, the assignment of mortgage. And then the next question was, we don't have a corrective assignment here today, do we? No. Your Honor, there was nothing. There's no competing evidence. There's no concrete evidence whatever that contradicts the fact that this note and mortgage, they both were assigned to FF13, not to the plaintiff, which was FF08. This is not a Scrivener's error. If there was a Scrivener's error, there should have been a corrective assignment of mortgage or something to contradict the fact that the trust FF13 has this note and mortgage. The section of the statute cited by counsel was not 673-1031, but rather 678-1031. And to suggest that the trust doesn't matter is just disingenuous. The plaintiff purports to be Deutsche Bank as trustee for a specific trust, not here in its own name, but as trustee for that trust. That's who's before the court, and the trust is fundamental. And lastly, counsel has suggested that to allow us to follow UCC chapters 8 and 9 would be catastrophic to the industry. That's just nonsensical. The debts exist. The trusts have been created in a specific manner in order to allow for the cash flows of the notes to be pooled and sold, investments sold as derivatives. The debt still exists, and there's still a right of action or entitlement to enforce those debts. It's just they can't be foreclosed on. So that's the issue here, and this is a trade-off that the trusts have made in order to get tax-free status within the IRS. And again, Your Honors, I would ask the court to please review this case and find for my clients and reverse the lower court's judgment in favor of the plaintiff. Thank you.
Thank you, Mr. Ackley. Thank you both.
Thank
We'll
you.
move on to our third case on the docket, which is Fannie Mae versus Doherty.